Good afternoon. Thank you very much for joining us today. And today we will be looking at Tales from the Frontline, property licensing and HMOs. I'm just waiting a couple of moments as the room fills up. We've had over 250 people registered to attend today's webinar, and more will be watching on catch up. So it's great to see that there is so much interest in today's topic. For those of you who have been with us before, you already know this. For first time viewers, thank you very much for tuning in. You're in mute mode by default, and that's to help other audience members to hear more clearly and not be distracted by background noise, but we do want to hear from you. And we have a specific section or time boxed off at the end for questions. So if you have any questions as we go through, any comments or feedback, please use the GoToWebinar box, which looks something like that, which is displayed on screen on the right-hand side of your screen. In the usual way, today is for general information purposes only and shouldn't be construed as or taken as legal advice or official guidance. And it's worth reiterating that our attendees today, so our panelists, are here in their personal capacity and are not representing any organisations that they may otherwise be related to. So they're here in a personal capacity only. And with that, I'd love to introduce our expert panel. So taking them in turn, Paul, would you like to give a brief introduction to the audience of who you are and your background?
Yeah, certainly. I'm Paul Conway. I'm the CEO of a property compliance software platform. And yeah, I've been running for the last few years, and yeah, I've been working with Fixflow on some content and support from licensing compliance.
Brilliant. Thanks, Paul, and thank you very much for joining us. And Matt, would you like to give a brief introduction?
Yeah, of course. So my name is Matt Willits. I work for a, like it says there, London-based local housing authority as an environmental health officer. Been doing that for about the last 12 years now, and heavily focused on HMO licensing for about the last 5.
Thank you very much for joining us today, Matt, and for both of you sharing your expertise. Over the next 45 minutes, our job is to help to provide some more clarity and insight around the licensing process, some of the pitfalls and some of the tales from the front line, and we hope that everyone who attends today will end up with a better understanding of both the theory and the practice around HMO licensing. That's our job today. And so without further ado, I'd like to go into the overview. So HMO licensing, property licensing is really complex. There are varying requirements. I'd like to understand, are there any common misconceptions about licensing that we should start with clarifying before we get into some of the more meaty topics? Matt, would you like to kick us off on that topic, please?
Yeah, no, sure, that's fine. So a lot of people think there's some sort of money generating scheme for local authorities. It's absolutely not the case. So by part of the legislation, it has to be cost neutral. It's a lot more time consuming than many people think. Multiple consultations need to be done. Lots of, property ownership can get very complicated these days, and obviously a lot of people need to be consulted with regarding the license. And I think the main thing is that the key point of an HMO license is to ensure that the residents in that property are kept safe, and that is the bottom line for the process.
Brilliant. Thank you, Matt. And Paul, I know that you look at the industry from a slightly different view. What do you think the key misconceptions are from people you deal with?
Yeah, certainly. I think it's around who is responsible, and Matt have dealt with this so many times himself as an EHO. And in summary, you have persons managing and persons in control under the Housing Act. And when you have an asset, a property, you have, say, letting agents, estate agents, property managers, and the actual owner themselves, and sometimes other people within the chain creating income from the property. So it's multiple businesses making money from an asset, and that's what licensing has done, is make all these people responsible for that. So yeah, there's a lot of risk on letting agents and everybody kind of in the chain. So it's making sure that everybody knows who's responsible for what, and making sure that your risk is covered.
Brilliant, thanks, Paul. And I think we're going to pick up on some of the tales from the front line, particularly around letting agents later in today's session. Looking to what's happening in the world of licensing, what trends are you seeing in terms of applications, and what do you think the trends are telling us? Paul, would you like to kick us off on that, please?
Yeah, certainly. I mean, there is a slowdown in applications at the moment in time, but trends and what we are finding is what's happening after application is the problem, and most notably getting the application and everything in line at the start is the most important part of the journey. What can seem really simple, and maybe an EHO or a local council might disagree, because in some councils they try to make it very easy to apply, and sometimes it can be. But for example, notifying all relevant parties as per the Housing Act by yourself, whoever the applicant is super important, because the trends we're finding are the problems that ensue afterwards, as Matt had pointed out, around ownership, and if you have to notify freeholders and mortgage companies and other interested parties along that journey, yeah, there's a serious amount of issues that come out of that. So yeah, that's the trends that we're seeing.
Yeah, so I think we're going to come back to some of the technical requirements around the application process that trip people up as we go through this. I think this is a theme we'll keep coming back to. And Matt, what are you seeing? Are you seeing any trends off the back of COVID or anything else?
Well, yeah, I certainly think it's fair to say that the number of licenses coming in has certainly dropped, as Paul was saying. Certainly within London, we've noticed that some people have rescinded their licenses. That simply put, the tenants aren't there at present. They've gone home to wherever their families are from, or they've just decided to go and move out, and commute in instead, or the whole working from home piece change things too. We've also seen a slight increase in properties converting effectively from short-term lets, so sort of Airbnb type properties, into HMOs. So there's going to be a big change, I think, in the property market as a whole, and I don't think many people know exactly how it's going to pan out. It'll be interesting over the next couple of years to see the post-COVID response to how the housing market has to change to meet the demand that is or isn't there. It'll be interesting.
Absolutely, and I hadn't really thought through the move from Airbnb to HMOs, but it makes sense as people search for yield and short-term stays just aren't there as a market. Moving on to compliance and I guess the life cycle of licensed properties, what are the key considerations for property owners and managers? Matt, would you like to pick up on this, please?
Yeah, so at the point of application, things may not be exactly right, but obviously the whole point of going through the application process is to funnel things in to be correct and to get things right. And the other thing is that the way the license is worded and written and designed is to help people stay there and keep the property in a safe condition. Obviously, there are penalties for breaches of the conditions, and that's about ensuring that the conditions are continue to be met. In terms of considerations for property owners and managers, I think communication with your tenants and making that as easy as possible. So, even if like each property has an email address or something, and there's, oh, this problem's going on, just so that there's that simple way of communicating with people will mean that things that are minor problems don't become big problems, and certainly, don't get to the point where the council get involved, which ultimately is what most people don't want.
Thank you. It's some really good practical advice there. Paul, is there anything you'd like to pick up on compliance and the life cycle?
Yeah, certainly. I mean, I think quite really the wording of life cycle is super important, and have been to some councils' presentations on when you're supposed to be doing certain aspects of compliance. And I see licensing as a kind of formalisation of things that you should be doing anyway, which is quite interesting because you have HMO Management Regulations 2006, 2007, Fitness for Humanitarian Habitation, obviously the HSSRS, RRO, Regulatory Form Order 2005, all these laws and regulations, and then guidance notes on LACORs and British standards, and all these things are there anyway. And what I've seen as guidance from councils is like, don't worry about it, just wait till we turn up. And the problem with that is that some councils don't even respond. Our longest time for a response on a licence application has been over 2 years, and you just aren't scot-free until whoever Scott is. But anyway, it's like if it's his fault, it's somebody's fault. But if something does happen within that time, there's things that you need to put in place, and there's legislation out there that you need to be aware of. It's not just a one touch, I'll apply, everything will be okay. But of course, there is one part of the really important process, and that's applying for a license, because then the council can't fine you for not having applied for a license. And obviously, at that point of application, your risk, well, part of your risk on the regulatory form under the rent repayment order 2000 and odds is away. So that's some really good part of your risk that's gone away. But as for physical compliance and safety within the home, it just doesn't go away on application, unfortunately. But as Matt pointed out, it's their process is to make that better. And from our point of view, yeah, definitely we see inconsistencies from councils to councils, from environmental health officers to environmental health officers that could do with streamline, and that's what I've been involved in the past, is making sure that landlords and agents are treated fairly and not over-spec'd by councils, etc.
I think that point about variance between councils is really interesting. Just because you've seen and understood one set of requirements, don't assume it will apply in any other area, or in fact that it will apply in the same area, because things may have changed. So always read and understand and go for expert help if you're unclear or just want some reassurance as well. And I guess going to the frontline part of this, without identifying any individual or any organisation, what are some of the most challenging cases you personally handled? Paul, would you like to kick us off on this?
Yeah, I'm sure, like anybody in this game, we've found some real challenges, and one that will probably resonate with the viewing audience just now is we had one of our partner agents come to us with a problem where one of their letting managers had squeezed in an extra person and not put them on the tenancy agreement, which became a problem. There was email evidence of that. The council found out, and we had to run around trying to fix the problem. So yeah, I think that something that we need to understand is that the problem isn't with the well-intentioned kind of management, with the well-intentioned trying to comply from that. Just because you understand that, it's very difficult for everybody else in your team and your organisation to understand this stuff, and yeah, that is where the weak points come in, where property managers or letting managers just maybe don't understand it. I mean, like an example that I gave is probably very rare, and as you say, probably you'd said before, probably shouldn't be in the industry anymore. But yeah, it's your weak points as companies are with that advice of people thinking they understand the legis. Oh, you do need a license. You don't need a license. You don't need to worry about fire risk assessment. It's not a HMO. Oh, it's not a HMO, so you don't need a license. But of course, family homes and one or two people can do, and it changes, as you say. I mean, licensing changes throughout the UK on average every 9 days. And that's just licensing. Never mind Article 4 planning permission, individual council rules and costings and how they all vary, and people's and environmental health officers' individual opinions, which is obviously what we're trying to smooth out along the way as well. So yeah, hopefully that helps.
And the point about sort of it needs to be bottom up as well as top down, so that managerial understanding of the requirements and the desire to implement them doesn't obviate the need for everybody frontline to actually understand them, because whether deliberately or more likely accidentally, they risk breaching it and bringing the whole company into disrepute and more.
Yeah, correct. I mean, like from my point of view, and like, I mean, thanks for your kind words in the past, calling me a HMO and licensing expert. Like it's one of those things that as you seem to know more about a subject, you know less about, you feel that you know less about a subject. And yeah, it's so complicated that, like, I mean, like, whenever if you're ever getting advice, whoever you take advice from, is make sure that they are qualified, experienced and accredited, and that's somebody that, for example, environmental health officers accredited by the Chartered Institute of Environmental Health, and planners, RTPI, etc., just make sure that they're actually accredited to give you advice, because on average they'll probably do a better job.
And Matt, what are your most challenging cases from the front line? Again, not mentioning names, please.
Yeah, so I suppose, I mean, sometimes you get people, they have like a rough idea of what they need to do, and they sort of grab hold of that and run with it, you know, very happily send in the form, think everything's going to be fine. And then, you know, I'll go around and visit and then go, actually, no, you should have done this, you should have done that. So people are invested, you know, they spend a lot of money thinking they're doing it right. and then actually I turn up and just rip the carpet from underneath them really, and tell them that effectively they've wasted a few £1,000s and they need to redo what they've already done. And that is not a great experience for either myself or the landlord or the managing agent, whoever it is that's done that. In terms of worse sort of cases, I have come across something where an HMO property was also involved in a rent-to-rent sort of scam, for want of a better phrase. So owner of property thought he was renting it out to 6 individuals. Turned out there was probably about 20 of them in there. The rooms had been split up, beds and sheds in the garden, the whole sort of lot. Needless to say, that became quite a large part of my caseload for a while, a couple of appearances in court, and also involved effectively a large number of people effectively being made homeless, and therefore the council then having to rehome these people in the short term. So it's a difficult scenario.
I would like, just for the audience benefit, I've known Matt for a couple of years now, and he's definitely not heavy-handed when it comes to this sort of thing. He's really pragmatic and reasonable. So yeah, you will get a varied of people, environmental health officers, etc., out there. But yeah, I quite believe Matt is very, very fair, and when he comes out to a property and understanding that when we first did work together, the understanding that there was a real need for really nice homes and properties and rooms within areas, and understanding why that was. So yeah, it is interesting.
Thank you both very much. I'm just going to pause here to remind the audience that if you have any questions, comments, thoughts or feedback, please put them into the comment box on the screen. We've already got a flurry of questions coming through from our expert panel. My colleague Remy is currently compiling them and moderating them, but if you have any questions, please do put them in. Moving on to the next topic of enforcement and complaints. What are the most common complaints submitted by occupiers? So what do occupiers mainly complain about? Matt, do you have a sort of hit list of things that come up?
Yeah, I suppose so. I mean, I guess you could view them as sort of quite minor things. And as I said earlier on, it's important really to ensure that minor problems don't become big problems. So we quite often are dealing with things like water leaks, the sink in the flat upstairs has leaked through the ceiling, that sort of thing. People with fire safety concerns because there's an alarm panel, a panel going off on the alarm. Pest problems, noise and antisocial behavioural issues, to some extent wear and tear in the common parts. And I think ultimately there is a direct correlation between the management of a property and the number of complaints that end up at the council. I think it's important to remember that ideally complaints will go to the landlord, manager, agent, etc., before they come to us at a council. That would be the right way around doing it. All of us that are part of this know that's not always the case. But ultimately, again, it comes down to the communication. If the communication is there, then ultimately it will enable you guys to deal with these minor issues before they effectively become blown up and the council get involved.
Thanks. And the correlation between the way in which people deal with reactive maintenance and planned maintenance, the communications around that and any potential consequences, I think clear for everybody who's involved in this sector. But it's really good to have those sort of buckets and examples there. And Paul, what about you? So what do you see the most common complaints as being, or what would you like to add to this topic?
Yeah, firstly, I'd like to add that, like once it does get raised to a local council or environmental health officer at local council, that's where they kind of dig into a lot of other things. They'll find out, do you have Article 4 planning permission? Do you have a license for this family home or small HMO or whatever it is? Have you looked at the fire safety? Have you looked at this? And even if you don't need the license, they still have the powers under HSSRS to make sure, as I said, all these other rules are still apply, and you don't even need to have a license for them to come into your property and make sure these things are okay. So they make sure those things are sorted anyway. But as when it does get raised and goes to this point, they do to look at everything. And then yeah, for me, I think that kind of things that kind of come up along, I think Matt's done a really good job of kind of highlighting everything from that perspective. I suppose adding that when these processes start, tenants have a lot of questions on like, why are these people coming to my house? Why do I need to? Why does that mean that my fire safety was substandard before this point? What does that mean? What blah 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 blah. oh, I don't want them to have access, which can cause problems. And yeah, having the answers to that prepared is probably something that should be advantageous. Yeah.
Absolutely, and I think you touched on something really interesting there, which is if tenants are preventing access or stopping works from being carried out, that could be one of the warning lights out there. And I know we've talked about that generally, and tracking requests for access and denial to see whether there is a pattern is both useful for this, but I think also depending on sector and approach, it could also be an indication of antisocial behaviour or domestic violence or a whole range of other things. Just generally, prevention of legitimate access could be a warning sign for property management generally. And then what can property managers do to help resolve complaints before they get to EHO? So Paul, what's your view on that?
Yeah, I think it's, as Matt's kind of pointed out, it's really straightforward, and I think that like we work with some amazing property managers throughout the country, and the relationship between them and the tenants, and as you say, monitoring the communication is just super important. You know, that's the key to it. Understanding what the problems are before they well, you can't understand a problem before it arises, but as they arise, making sure that they're dealt with efficiently, and that should keep you in a good stead before the environment health officers first step in.
Brilliant, thank you very much. We come back to that theme of communication and transparency and responsiveness again through this in terms of managing the relationship, stopping escalation, and also I would expect reducing the cost of mitigation for damage to buildings and protecting net yield for investors if things are nipped in the bud early. Matt, what's your view on this?
Well, yeah, I mean, I've said it a lot already about, you know, communication, sort of, and transparency, like you say, engagement with residents. I mean, visiting your properties is key, because that's when you'll get a good idea as to what's going on. You know, identifying repeat issues so that things can be done on a proactive basis as opposed to reactive. Yeah, prioritizing repairs. You know, tracking progress and completion, you know, and again then saying, okay, highlighting to the residents that that's been dealt with now, and you know, adding on, please feel free to come back to us. I suppose the difficult one is antisocial behaviour issues that obviously get escalated to HOs. I mean, it's not an easy topic to deal with. It's not an easy topic for us to deal with, and we've got legislation behind us to help us. You know, but the big one I want to say here is, please don't ignore antisocial behaviour issues, because that really is one that will start off as a small issue and will only get bigger. That's certainly one big take home from today, I think.
Brilliant, thank you. And prioritisation is something that we've seen take on increased importance during the different phases of lock and unlock. So being able to identify that which is an emergency or a risk to people versus that which isn't, that which will escalate or accentuate over time versus that which won't. So from the Fixo system, we saw a marked drop in non-urgent repairs being dealt with, and that backlog, I suspect, is getting worse over time, and those issues now need to go back and be fixed. And there's also the compliance issue. So I think an appropriate triage and prioritisation process is a must-have for people operating in this sector. We're going to go on to what's changing. So what is a discretionary licensing scheme? Paul, do you want to pick up on that, please?
Yeah, certainly. Yeah, I mean, basically the council do have the powers to introduce their own licensing schemes within councils, and they can be borough-wide, they can be ward-wide, they can be street-dependent, they can be area-dependent, etc. And they can have this, as I said, from as low as, you know, a family home or one or two people sharing a property, also covering small HMOs as well. But if they want to run one of these schemes, and what they are trying to do is tackle antisocial behaviour, safety issues, etc., but they have to gather data on that and apply to the government to input one of these schemes into the area, and they go through a consultation period, and then they get input from local residents as well before these schemes are made live.
Thanks, Paul. Matt, a general question for you, which is, how are you dealing with the risks of COVID in your role? Has anything changed?
It changes on a very regular basis, to be fair. I mean, we've gone from points where we've not been visiting people at all. We've gone to points where we're only visiting absolutely, the most dire cases where we have sort of almost definite proof of a category 1 hazard or a risk of serious injury to people within properties. What we have found is that ultimately, actually, quite a lot of minor works have been able to be continued to be carried out, and actually, certainly where I'm working at present, I'm quite pleased with a lot of issues that have been dealt with very quickly by landlords. It's more the planned stuff now, I think, that's going to take a long time to be picked up. The other thing is, obviously, actually, in this sort of instance, having the register of licensed properties is really helpful for us in terms of outbreak management and control, because obviously when you've got a large number of people living within one property but living separate lives, actually there is a risk of transmission within a property there. But we've been able to identify properties we feel are most at risk, and have been able to suggest to the landlords, putting in extra controls to try and keep the residents, as I said earlier on, keep them as safe as possible during this time.
Thank you very much, Matt. And we're moving on to audience questions. So please do continue to submit them. We've got what I'll describe as 2 pages of questions already. As a general approach, what we'll do is try and ask general questions that are really valuable to the audience, or a large part of the audience, rather than anything particularly fact specific. But at the end of this, you'll all get Paul's contact details, and he would be the right person to contact on any specifics that you want to pick up, given that this is his area of expertise and also his business. So the first general question is about the rogue landlord register. Thankfully, it's been written as rogue rather than rouge, which is one of my pet peeves. How does the rogue landlord checker work? Do landlords have to register their rental properties? Who'd like to pick that up, please?
Yeah, I mean, I could start with that. So landlords don't register. Well, no landlord's going to want to register themselves onto a rogue list. Effectively, it's for the councils to put people on those lists. If we end up to the point where we take enforcement action and are successful, be that within a court or within a tribunal, then that will get them on that list. Depending on the severity of that, depends on how long they're on the list, and how visible it is. And that's the argument at the minute, is whether or not it should be a publicly accessible document. At present, it isn't. It's only visible to different local authorities as a way of information sharing, because let's be honest, landlords' portfolios don't stop at the borough boundary. People own houses and properties wherever they happen to own them, and actually being able to share the information for local authorities has been a big help to us. The exception there is obviously London has that open access one, so you can see whether or not your landlord has been in front of a local authority for issues with the property. And it is that consultation at present as to whether or not that approach goes across the rest of the country. It was due to be discussed earlier this year at the Houses of Parliament and House of Commons and things, but obviously with COVID, it's been delayed, and unfortunately I can not tell anyone how long it's been delayed for or when that will happen, but it's something to keep an eye open on.
Thank you very much, Matt. Paul, I think the next question is right in your wheelhouse. So, do property agents have a duty to ensure the landlord has the right HMO licence in place before they find the tenant? So if you could talk through the timeline from a letting agent's perspective, and when they need to ensure that the appropriate licence is in place.
Yeah, certainly. I mean, I get asked this in very many ways. So basically, you advertise the property. Well, there's a few questions you could ask yourself before that. Is this property actually fit to be licensed? Will it pass licensing? Should I have, should we look at it? Should I get an expert point of view, etc., etc.? Because what sometimes happens is that you start on this journey, and as Matt says, you might think that you understand what's going to happen next, but you don't. And then in some cases, what you find is that there's a lot of unforeseen costs along the journey as well, and landlords don't really understand what they're going to be. The agent hasn't advised them that this is the process that is going to be going through, and the costs and hoops that are going to have to jump through, and then ultimately you could jump all through those hoops and then not get a license. So it could be some very unhappy and are some very unhappy landlords that we've kind of came across from that. So, but in general, after that is you advertise the property. You find the tenants, you sign the tenancy agreement, and then apply for the license before the tenants move in, and that's the process. Of course, obviously we've touched upon lots of other things you're supposed to do to make sure the property is compliant, etc., and things that you can do to mitigate you and your landlord's risk. But that's the process that's supposed to happen.
Thank you, Matt. Recognising this is your view as an individual rather than anything else, where do you think people stand with regards to fire safety checks during COVID? And I think that was in response to a comment you made about the sort of planned stuff rather than the minor reactive works. Are you seeing fire safety checks being carried out with the same speed and regularity, or is that a bottleneck in this process?
Yeah, okay. So it's to be honest, it's very dependent upon the landlord and also the residents. I mean, residents are perfectly within their right at present, really, to say, no, I don't want someone coming into my room to check this, that, and everything else. Common parts should not be a problem. You know, a letter from the landlord saying, you know, between such and such a time on such and such a day, can you please ensure that you're not entering the common parts of the property whilst certain checks are being done. But similarly, I think out of all of the officers and whatnot that are doing works in HMOs at present, I think probably the fire safety checks are the ones that are getting slightly behind, and I think it's more to do with access than anything else. But I mean, certainly where I work at present, we're being lenient with regards to things like gas safety checks and fire alarm checks being submitted exactly on time, purely because of the issues of access and lockdown and things like that. But then at the same time, we're very aware that we don't want that to be taken advantage of. Yeah. It's not there to be abused. It's about us being helpful to people and taking some of the pressure off. Because let's be honest, you know, this is the sort of thing that's affecting everyone. Everyone's under a lot more pressure than normal at present, and if we can make life easier but still maintain safety, that's not a problem. For instance, if you have a very good history of compliance, then we have absolutely no reason to worry too much about the new certificate being, I don't know, six months late or something. Whereas if we've had to chase you in the past, or there's been big problems in the past, then we're going to be pushing for the new certificate to be coming in sooner rather than later, because it's about managing the risk, and triaging was something that was mentioned earlier as well. I guess on that basis, yeah.
Brilliant. Thanks for that. Paul, I'm going to jump back to one of the points that I think you made at the start, which was around understanding the different people involved through the licensing process. In a rent-to-rent scenario, which party should be the applicant for the license, the rent-to-renter or the owner of the property?
Anyone, really. It doesn't matter who is the applicant, and I don't think it really matters who the license holder is. I mean, some councils are very specific are more specific. They've got to be a UK resident or UK company. Some will allow overseas landlords, and with, as long as they've got UK property managers and things like that as well. So the applicant doesn't really matter. It's more who the license holder is. And some other restrictions we see on license holders are that it can't just be your auntie's cousin's brother, because they just don't like that. It's actually somebody that's supposed to be related to the property in some way, not just you. And a lot of that, well, there's a lot of risk to being a license holder. And interestingly enough, two people could ask me if a rent-to-rent property manager or let an agent phone me up and says who should be the license holder, I'll tell them the landlord. If the landlord phones me up, I'll tell them the license holder, depending who my client is, because it's who's going to hold the risk mainly. So yeah, it's an interesting question.
Brilliant, thank you. And I think the next question is actually going to bounce off both of you. So it's a theme that's come up through some of the questions. I'm going to do my best to summarise it if I can. Do agents have to check each and every property regularly to detect illegal lets, and how often should they check properties? And then secondly, some councils say that there is a 6-monthly inspection as best practice. How, if at all, is that affected by the current scenario, which inspections might not be as possible, or access may not be as readily granted? So I guess taking that sum as a whole, how do you view inspections? How often do you typically see inspections being carried out, and what would you suggest, recognising this is of course not official guidance or advice? Matt, would you like to kick us off on the point around inspections?
Yeah, that's fine. So I think probably as an average, you're probably looking at annual inspections. You know, I mean, bearing in mind, not everyone lives around the corner from the properties that they own and rent out. You know, it's not always that easy to organise. You have to give the tenants at least 24 hours notice that you're coming in. You know, it's not just a case of letting yourself into a property that you own and rent out. You can't, you know, that's obviously not feasible. I'd say better practice. Obviously, the more regular, the better. But at the same time, you don't want to become a pest landlord, because it's just going to make the relationship between tenant and landlord sort of worse. If you're looking after your properties well, then obviously that one annual inspection will be fine. If you've got a property that's got an awful lot of wear and tear, then you're better off being on top of it, you know, more often. It's a personal preference, really. There's certainly no council's going to say you must visit their property every 3 weeks or something like that. You know, that's unrealistic. And in terms of COVID, like I said earlier, with COVID at present, it's not something to be pushed. You know, you don't, as much as it's your property, it's effectively where a lot of people call home. And it's their safe space. And you know, some residents within HMOs are sort of terrified as it is. You know, during lockdown, for instance, you know, even going to use the bathroom or the kitchen. You know, if it's all, you know, fully shared facilities. So suddenly, then having extra people traipsing around to paint walls and things, it's not necessarily that urgent and important, is it? So common sense, I guess.
And just to pick up on that, so do you think it's helpful for people to document why they think the frequency of inspection is appropriate for that type of property, and then to document the outcomes of inspections so they could show what happened during them? So I guess, to what extent do you think a paper trail around this is useful, if at all?
I think I've said it a few times about openness and communication between landlords, managers, and residents, and ultimately, like you say, about providing feedback on visits. If anything, it's going to make the next visit easier, because the residents are going to see a benefit to it. They're going to see the positive action comes out of landlord visit, as opposed to the almost obvious sort of scenario of, oh, it's just a nosy landlord just poking their nose around the property. You know, if they can see that the landlord's coming around to see the state of the property and to see if anything needs to be dealt with, you know, it's about making it easier and a nicer process going forward, I suppose.
Thanks, Matt. And Paul, do you have any views on inspections, whether frequency, method, or anything else?
No, I think that Matt and yourself have covered it well. I think there's you have this, you know, as you say, an official inspection, but you also have other things going on throughout the year, like fire safety checks and, you know, gas checks and maintenance visits and all these things, and other things can be picked up and are picked up on visits with good relationships with the companies that you're working with, I guess, that can pick up other information while they're at the property. And I mean, eyes everywhere are important. So yeah, you will have regular or, you know, I think, like Matt said, annually for an official inspection, it's probably as a minimum in my eyes. You know, 3 monthly is probably a bit too much. 6 months is probably pretty good. But yeah, you should be doing a minimum of yearly. But there's eyes and ears everywhere, and there's other means that you can keep an eye on your property, and not documented, but also keeping an eye on it, shall we say.
That is really helpful, thank you. I'm conscious that we're running low on time, and actually the questions are still streaming in. So I'm going to ask a couple that I think might be quick fire. One of them is, I think, for more general interest, I'm guessing. It goes back to the example you gave, Matt, of sort of a subdivided rent to rent, the worst case or one of the worst cases you've seen. If an illegal let is closed down and the tenants are temporarily rehoused by the council, who pays the cost of that? Is it the landlord or was it the council? This is maybe or is there a general approach to the recovery of costs?
Well, I mean that there's a big can of worms there in that answer. Well, sorry, in that question. In terms of an answer, there's no short answer to that one, unfortunately. But it all very much depends on all of the ins and outs, and I guess to some extent following the money. In rent to rent, it all ends up about following the money, and it's, well, I said earlier on about the licensing process going to be quite time consuming. Enforcement in this situation is even more time consuming, and yeah, finding out the relevant party and things sometimes can ultimately cost more than providing the temporary accommodation, to be fair.
Thank you very much, Matt. And Paul, I'm going to pass the next one to you. Are you aware of any changes in the fire safety standards for HMOs? And this has come up in 3 different guises, actually. I'd say the same question. I think the audience would like to know what you think of changes that are coming up, if you are aware of any, in terms of fire safety standards.
Yeah, I mean, there's from the core a huge amount of confusion with that, which I'll go into in a minute. But of course, there's the Grenfell report that's coming out. Some of their standards will be applied retrospectively, I believe. So it's not just about new things that are happening in buildings. It will be old buildings that currently are in place that new rules will be applied to. So we'll have to watch that carefully, and something that we're obviously building into our platform. And then from a kind of like, why is it different, what is going on, etc., etc. You have the law, you've got HSSRS, the HMO Management Regulations, Regulatory Reform Order 2005, and then so you have law and then you have guidance notes. So based on guidance notes, for example, LACORS is a guidance note and something that council use heavily, and obviously the British standards and all walks of life are really important as well. Luckily enough, unluckily enough, both of them are different, and for BS 5839, which was fire alarms, changed last year, which was really helpful as well, which added to more confusion. And yeah, it is going to be super confusing. Making sure that you get a fire risk assessment, again by a qualified and competent person. If when we do fire risk assessments, we have a qualified fire risk assessor that can prove competency, and then they're overseen by one of our environmental health officers, so that it's in line with council recommendations, which sounds absolutely bonkers that so many people are involved. But like trying to get that consistency that you don't see from councils or various other places or in other parts of the market is really, really important. For instance, you could have a fire risk assessment in the building and nobody will ever look at it. During a kind of licensing process, which could be, bear in mind, could be a flat or a full building of multiple flats, or it could be a house, etc., etc. Somebody else is looking at this, and this is where the council can come in and give their opinion, and that's what we try and give the same guidance on. So yeah, hopefully that helps.
And just to flag that the Building Safety Bill and the Fire Safety Bill are both going through Parliament at the moment. We are going to be hosting a webinar on the Building Safety Bill, we expect towards the end of the year, as we get more certainty that it is in final form. We're predominantly talking there about people who manage blocks, so whether they're build to rent, block management, student, social housing and the like, but please keep your eyes peeled for that. And I'm afraid that we've run out of time. But again, if you have any specific questions, then Paul is definitely the man to speak to, and you'll get his details at the end of this webinar. I'm really grateful that you've all turned up. Matt, Paul, do you have any final thoughts that you would like to share with the audience before we wrap up? Paul?
Yeah, I imagine that was quite a lot to take in. I guess it is a difficult and time-consuming journey. I'd just like to reiterate that take advice from people that are accredited at every part of the journey, and that would be my main bit of advice.
Thank you very much. And Matt?
Yeah, I just want to sort of echo the same, really. I guess if there's any doubt, then please ask. It doesn't matter who you ask, just make sure that the person that you're asking, like Paul says, is qualified and a suitable person. but please don't just go head on down what could be a complete tangent. It won't help anybody unless you're very, very lucky and you happen to go along the right path.
Thank you very much. So thank you to the audience for attending. Thank you very much, Matt and Paul, for sharing your time and your expertise and insights with the audience. At the end of this, you'll be asked to provide some feedback. So we want to know whether this was interesting and useful to you. If you have any other suggestions or comments, please do tell us. The next webinar in our series, this is about our webinars generally, so there's a stock of them available on demand from our website, will be about mediation. So predominantly for letting agents. What is mediation? Why might you want to recommend your client to go through mediation rather than a court process? And how does it work? And we'll be joined by representatives of Hamilton Fraser and the Property Redress Scheme as part of that. Thank you all very much for joining. I wish you all a wonderful end to the day, and thank you again to Matt and Paul. Have a great day. Bye.
Thank you.
Thank you.